that I'll go ahead and start at 1 o'clock. My name is Carolyn Safran, and I serve as the chairperson for the Social Work Advisory Committee. Andrea will not be chairing today. She will be listening to this conversation, but probably will not be able to input as much. So I asked the members of the advisory committee to respond to roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic.
Volume, press *2. To lower volume, press *8. To mute, press *7. To unmute, press *9. For operator assistance, press *0. To add a person, press *1. To disconnect the person you
Sorry, we're having a little technical issues with our conference call line. I think we got it resolved though, so.
Okay, so I'll go ahead and begin the roll call. We'll start with Andrea Perdomo Morales.
And I don't see her in the Zoom meeting right now, but I'll keep an eye if she should join us. So.
Okay. Danielle Johnson.
Present.
I know that Mike Gillette will be running a little late, and he will join us when he is able to do so. Leanne Ginnery. Angie Heller Workman. Jane Holtz-Richter.
Here.
Kristen Stice will not be here today. She called in and she'll be absent. Robin Unruh.
Here.
I note the following staff members who are also present: David Fye.
Here.
Leslie Allen.
Here.
And Ashley Van Buskirk.
Here.
And Carolyn, I also want to let you know that Sammy Barksdale is also in attendance as well from the BSRB.
Okay. The Assistant Attorney General, Janet Arndt, and Lane Barnett, who are assigned to the board as general counsel, are also present. Next, David, if I will read a message concerning this meeting held remotely.
Thank you, Carolyn. I just want to let you know Angie Heller Workman has just joined the Zoom meeting as well, so she is in attendance.
Okay, good.
My name is David Fye. I'm the Executive Director of the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or COMA, does not require the advisory committee to provide public comment or answer questions from individuals. There will be no public comment at the meeting today to ensure adequate time for the items currently on the advisory committee's agenda. And actually, I apologize, that is one error. There will be 5 minutes allotted to an individual providing comment on social work titles, protection of title for social workers. So that is one item that has been allowed 5 minutes for public comment. Public comment can be requested if an individual contacts the office in advance. Because we are conducting the public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Because the emergency declaration that was issued for the COVID-19 pandemic has been extended to March 31st, 2021, the meeting is being conducted remotely to comply with health and safety concerns at the board's conference room cannot accommodate social distancing for everyone in attendance. However, access to the meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements for the COMA are not suspended. As such, we'll be conducting this meeting pursuant to the COMA and KAR 16-20-1 concerning compliance with the COMA during an existing emergency disaster declaration. On February 8th, 2021, we sent notice of the advisory committee meeting to all individuals who have requested notice of the advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials was posted on the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fi@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and the YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. Each member of the advisory committee, staff, or presenter shall state the person's name and title each time the person speaks or votes. Each participant to the meeting shall ensure microphones, phones, and other electronic devices are on mute when the participant is not speaking. Each motion will be clearly stated before the advisory committee votes, and each advisory committee member will vote when their name is called. The chairperson will announce the result of the final vote. The advisory committee lacks authority to delegate a member of the committee to sign or staff to sign any binding document on behalf of the board. Thus, no such statement or motion will be made. A recording of the meeting will be posted to the board's website. The advisory committee has the following items listed on its agenda: call to order and roll call, visitors present or announcements, review and approval of minutes, advisory committee role and responsibilities training, executive session, old business, new business, and adjournment. The advisory committee's agenda includes an executive session. If the advisory committee elects to go into an executive session, the advisory committee will follow this process. First, the advisory committee must be in an open meeting before going into an executive session. Then an advisory committee member must make a motion to recess for an executive session that is seconded by another advisory committee member. Each advisory committee member will then vote. The majority of the advisory committee must vote in favor of the motion to exercise the executive session. The chair will announce the result of the votes. The motion must contain a statement of justification for closure and the subject to be discussed pursuant to KSA 75-4319B, and the time and place the open meeting will resume. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members return to the conference call, the open meeting will resume through the conference call. The complete motion for an executive session will be recorded in the minutes. And I would just ask now if there's any individuals on the conference call line. If you are on the conference call, if you could identify yourself. Okay, I don't believe that anyone on the conference call currently.
The meeting is now called to order, and the advisory committee will begin the discussion of the first item on our agenda. Excuse me. I'm sorry. Okay. So our first item would be visitors present and announcements. And as David mentioned, we have Sherry Kuschel, I'm hoping I'm pronouncing that right, the president of the Kansas School Social Work Association. And she indicated that she wished to speak to us for a few moments with the advisory committee members concerning the protection for social workers. And Sherry,
Thanks, Carolyn.
sure.
Yes, my name is Sherry Kuschel, rhymes with bushel. So I dated my now husband for months while I was pronouncing his last name wrong. So he finally said, it rhymes with bushel. So
I'll
there you
remember
go.
that. Thank you.
Thank you for your time. I appreciate it. David, I especially appreciate your correspondence, very prompt conversations back and forth about allowing me to come and visit with you for a few minutes. My question really is about title protection. As president of K-SWAB, that is something I'm very interested in, and did not think that social workers in Kansas had title protection, but I was on another meeting, and I think it was maybe Janet mentioned that we do have, social workers do have title protection. So I'd like to know if we do, where I could find it. And if we don't, I think that's something that might be, if we don't have it specifically even to school social workers, I think that's something that maybe I would be interested in if there's enough, interest in even a discussion. I'm hearing across the state, people being hired for school social workers that don't have a master's degree in social work. And so I am concerned about that because they don't have the education, they don't have the knowledge, especially in the mental health area. And then on the flip side too is that social workers are hired as school social workers, and then we're not being called social workers. We're being called lots of other terms, and I'm hearing that it's because we still have that really old, perception that social workers just want to take kids away from people, and so districts are hesitant to say they have a social worker, which I think, instead of that, we need to educate the public about what our role is, and that's not our role to take children. So I guess my first question is then, do social workers in Kansas have title protection?
Yes, is the answer. Leslie, can you specify where that's located?
656307, KSA 656307. And it says any person who possesses a valid, unsuspended, and unrevoked license issued under the provision of this act shall have the right to practice and use the title and abbreviations prescribed by the board for use by persons holding the license held by such person. The board shall establish a title and prescribe abbreviations for use by persons holding each class or type of license under the provisions of this act. No other person shall assume such titles, use such abbreviations, or any work or letter, signs, figures, or devices to indicate that the person using the same is licensed as such under the provisions of this act.
Well, that sounds fantastic. That's great. Do our, I guess my next question then is, do our administrators and superintendents across the state know about that statute? Because it's not being followed. And so, if they don't, maybe they need some training or whatever. And then I guess too is has there ever been any discussion about specific title protection to school social workers, so that we're not getting family and child development graduates or, somebody with a psychology degree that's coming in and they're saying they're a social worker, a school social worker?
Yeah, I think some education is needed. You would not be able to use the word social work if you were not one. So I think some education might be needed for your administration for sure. I don't know who do that.
I don't know that we could, I mean, I of course would defer to Jan, but as we don't specifically license school social workers, I don't think that we could protect that title. But I'm not sure.
Even with the
Social
word, even with the word social work in it.
Well, and I mean, then I was under the impression, and I've been a social worker for 32 years, that BSRB did license school social workers. I mean, we're under the social workers, nobody else licensed us. And we have to
Right.
do, the 40 hours of continuing ed, and our license comes from. So I guess I'm confused by that.
Well, but they're licensed as a social worker. It's not limited to school.
Right.
So they could go and do social work anywhere.
Right.
We don't determine specific requirements for a school social worker.
Okay. All right. So, so has there ever been any discussion or interest in having some of that? Because I think, our profession is growing. It's really exciting. The school social work field I'm talking about. So, we're not necessarily acknowledged by KSDE because we're not certified through them. And we're not, we're under the umbrella of social work, but is there any interest or even thinking it's appropriate to pursue something that's specific to school social work.
Well, my understanding is if you were a licensed MSW or LSCSW, you could practice in a school setting,
Right.
but you're not licensed as a school social worker, but you're licensed as a master's level social worker or a clinical social worker.
Okay.
But you can practice in different types of fields with those, licenses, child welfare, just
Right.
a variety
Yes.
of different settings.
Yeah, I understand that. I just, again, my question is that there are people out there that are working as social workers in a school setting that aren't licensed. And to our association, that's a problem.
Mhm.
So I don't know, again, who needs to do the education, where the clarification needs to come from.
I would think someone would file a complaint against the person who's using the title.
Mhm.
Well, it's the district that's hiring them. So you would file the complaint against the district?
Well, no, because that isn't, we couldn't do anything. I mean, the complaint is against a person, not the district, that's why. So I'm not sure how that would be handled.
This is Jane. Can I speak?
Yes.
Yeah.
What I'm wondering is because so many mental health therapists are now going into the schools, has that, Sherry, brought on part of the issue because they're the therapists that are going in and being contracted with the schools to do mental health services, to do therapeutic services, and they're licensed, therapists. Of course, some are social workers, some are marriage and family, some are psychologists, but the discipline. But I don't know that they necessarily have that additional hours of class training that the school social workers had to have. And so is that what's causing a little of the angst with all of this?
I don't know, but from what I'm thinking or hearing, I don't believe so. I think some of it is our rural areas. Maybe, they hire a BSW and they're doing school social work, maybe in conjunction with their MSW schooling. I mean, is that okay? I mean, they're, sorry.
This is Robin. I know the opposite is sort of true out here, Sherry, that we, like USD 457 are hiring master's level social workers as guidance counselors out here. And I think we all know there is a difference in the education, the master's level education. So that is, and the job description says counselor as opposed to school social worker. And there is a difference.
Mhm.
So I don't know how we would address that, but there is an education piece, and I think we all agree with that. But where to start with that is the question.
Yeah. And so, Robin, are those social workers that are hired as counselors, is their title counselor, even though they're a licensed social worker?
Yeah, I believe that the title should not have the word social worker. It could be counselor, school workers or something. You'd have to change the position of the title to exclude the word social work. If it was not a social work that was providing that service, would be my understanding.
Well, and from my understanding, a guidance counselor has to have so many different components that a social worker does not have. I mean, you have to go back and get that educational component to become a guidance counselor because of the scholarships and the academic piece of it that you're helping these children go to college with.
Right. And so again, that's kind of another piece of it, is that, people that aren't that don't have the social work degree are called social workers, and social workers that have the degree are called counselors, and we don't have a counseling degree. So it's kind of on both ends.
I'm more concerned to what you said, that would be the BSW being called a school social worker, because for me, a BSW would equal more of a case manager. An MSW would equal more of the alignment of a school social worker, or
Masters.
whatever at that alignment. It's more apples to apples with the degree.
Right.
And therefore I would have more of a question on that.
Sherry, I was wondering, since this sounds like this could deserve some extension in our conversation and discussions, and to allow you more time, I was wondering if you would want to put that on our next board meeting agenda, so you could elaborate a little bit more and that all board members could hear, but also that maybe you could just jot down specific questions to present at that board meeting, and that might be real helpful in guiding us to answering those questions.
Okay, sure. I'd be happy to do that.
We do appreciate-
Carolyn,
Yes.
this is Angie. I know that there's a
Angie.
statute with Kansas about qualified mental health professionals
Mhm.
that has the different counselors and social workers and everybody listed. Would a blanket name like qualified mental health professional be something like you're kind of considering when you're looking at, encompassing, I don't know, that's just something that I thought I should suggest, but anyways, go ahead.
Yeah, that's a good suggestion, Angie, because it sounds like the position title would need to reflect all professions and some different job title description.
But there is a Kansas statute on that they could look at.
I guess, and this is just, some of my personal bias that, I went to school for 5 years to get a degree in social work, and that's what I am.
Mhm.
And I remember having to correct people, as even my principal would say, oh, this is a counselor. I said, no, I'm not the counselor, I'm a social worker.
Mhm.
And so, I'm not I'm a mental health, whatever you want to call it. I'm a liaison, I'm lots of different things. I do lots of different roles, but my title is social worker.
Right.
But yes, I would be happy to come back. I appreciate your time. I know I'm way over 5 minutes, so thank you.
That's okay.
Is it okay, Carolyn, if I just stay on and mute myself and not, can I
Oh,
listen to the rest?
Oh, absolutely. You're more than welcome to do that.
Okay,
And
thanks.
if you wanted to send any questions to maybe David to prepare us for our next meeting and to provide a little bit more of an extension of time for these discussions, that'd be great.
Okay, thank
If
you,
you're-
appreciate it.
If you're needing information from us regarding statutes or regulations, certainly let us know. We could provide that information to you prior to the meeting.
Okay, great, thanks.
You're welcome.
Carolyn, I wanted to let you know, we had an individual join the conference call, I believe. So if you could identify yourself, go ahead. If you're on the conference call, just go ahead and say your name.
This is Angie calling in.
Oh,
Yes.
okay.
Thank you.
Hi, Angie. Okay, so moving on to our next agenda item, that would be to review and approve the minutes of December the 8th. And I'm assuming that everybody had received a copy. So are there any additions or editing that needs to take place in our minutes? And if not, if someone would make a motion to approve, if that's where we need to go. Give a few minutes to people looking at that.
I'll make a motion to approve.
Okay, Jane, thank you. Do we have a second?
This is Angie. I approved a second.
Thank you, Angie. Appreciate that. Our next agenda item is the training for board and advisory committee members, and Jane Arndt, our Attorney General Officer, will be right here. Jane. I think you're on mute. Oh, there
Try
you
to
go.
keep it. There we go. Okay. Okay, my name is Janet Arndt. I'm an Assistant Attorney General that's been assigned to the board as General Counsel. And the board, we typically give training to boards every year. This year, though, the BSRB decided to expand the training so that it went not just to the board members, but also to the advisory committee. So we've been going around to all the various advisory committees to kind of give you the same training that board members get, in essence, to help you assist the board in your role as an advisory committee, so that you kind of have an idea of what the board can and can't do and where the boundaries are. So that's a little bit of why we're here, so that you have a better understanding of that. Because as a government licensing board, your role is different than what you would have if you were on a board for a private organization. So there are differences. So we want to make sure that you understand, you know, that working for a state licensing board, you have those boundaries. So how do you get the boundaries? It's basically through statute. The board is a creature of statute. And that means then that that they create the statutes that give you that creates the board, and that also will tell the board what they can and can't do. There's other licensing boards for doctors, nurses, real estate brokers, police officers, barbers, cosmetologists. So there's all out there. There's some similarities between the licensing statutes, but there's also a lot of differences. And so that it becomes very important to know which statutes and which licensing acts that you're under. All of the purpose for all licensing boards is to protect the public. It's not to protect the licensees, it is to protect the public. So that is always your goal, and that should be your focus, is that you make sure that professionals are competent and don't pose a risk to the public. The way you are created is what we call an enabling act. And that is the act that will set up the board. It tells how many people are on the board, what their background has to be, what their terms of office are, and then what the duties and authorities and powers of the board will be. That is essentially what you do. You are going to administer and implement and enforce those statutes that they give you the authority to do so. A lot of times what is kind of an issue for a lot of board members, when they are saying we want to do something, they'll say no statute prohibits this from doing it. That's the wrong question. The question is, what statute authorizes you to take such action? That's the whole reason why, because you're a creature statute, you've got to have a statute that somehow authorizes you to take that. However, besides your statutory authority, there's also constitutional limitations. The most common are going to be equal protection and due process rights. And that basically prohibits a board from acting in a manner that results in some kind of inconsistent treatment of persons that are similarly situated, having different standards in certain situations, or otherwise that acting arbitrarily, capriciously, or even vindictively. So in short, what it means is that you may not discipline someone more severely just because of their gender, their race, or some other reason, that it's even as simple as that you don't like them. You have to stay within your boundaries of what it is for, like perhaps taking discipline against someone or even licensing someone. Other constitutional issues can be freedom of speech, rights of privacy, unreasonable search and seizure, and vagueness. Vagueness usually occurs in a statute or in a regulation. The main thing to remember is that the Kansas legislature remains in control over pretty much everything a licensing board does. So if the legislature were to repeal your Enablings Act, that means the board is essentially eliminated. There is no board anymore. They could also reduce what your ability, your powers are. Perhaps take away some of the powers to do certain things against licensees, or perhaps to broaden the people who can be licensed. You are a fee funded, which means that the people who want to apply for licensure and then the ones that are licensed have to pay certain fees. And that is a fee funded agency. So you have to operate your budget off of the fees that you do collect. However, you can't just automatically spend whatever you create. Those fees will go into a general fund, and the legislature then will do an appropriations that will allow you to spend the funds within the guidelines that they give you. The other thing, as I said, sometimes you look at, is there something to prohibit me from doing this? But the other thing is you need to understand is there's a distinction between language that uses may in a statute and language that uses shall in a statute. May just means that you have discretion. And so discretion needs, when you have that, you need to use it. So that means considering all the facts, considering the background of the person, considering whatever conditions surround what happened, weighing that and deciding, what you need, what would be best to impose discipline. Shall, however, means that you don't have any authority, that you are required to, if they meet that criteria, then you have to do it. And kind of a good example of where those two types of powers come together are in your licensing part. Because if you look at your licensing statute, it will usually say that the board shall give a license to someone who has these qualifications. And then they'll set forth the age and the education, the degree and the coursework, that kind of thing. And if all those are met, then it's a shall and you give them a license. However, there's another statute that we often refer to as a discipline statute. And it says that you may condition a license or even deny a license if certain other factors exist. And like a very common one is that they have a felony conviction, then they have to show they've been rehabilitated. So even if they would meet all of the qualifications under the shall statute, then we go into the may statute because they had that felony convictions, and you have to get information from them that shows that they have been rehabilitated and that to the extent that the public is now protected. So that way the board knows that even though they have this criminal conviction, the public will be protected by giving them the license. So the two kind of work hand in hand. Sometimes the other thing is that when boards will want to do shall when they don't, when the legislation says may. And so that is where you need to really, they want to have like what we call a blanket rule, if this, then that. And you can't do that. If you have discretion, then you have to exercise that discretion. Otherwise, an appellate court is going to say that your decision was arbitrary and capricious because you did not use the discretion that you were supposed to do. And again, back to what you'll probably hear a lot is that when you make your decision, you have to have, the purpose is to protect the public. And the whole way of doing that is to license people who are competent and have met all of the standards. And then if someone after they're licensed violates the rules and conditions, then to take disciplinary action against them. And you have to weigh, with discipline action, there is a broad spectrum from perhaps giving them just a warning letter to revoking the license. There's a lot of in between there. And that's where the may comes in. You have to look at all the things to figure out where on this spectrum is the discipline that needs to be imposed. If you go back to your government classes from long ago, you're going to remember that there's three branches of the government: your executive, your legislative, and your judicial. The board sort of has all three of those types of functions. And sometimes those can get kind of blurry. But you kind of got to try and remember, which act you're under. Executive authority is basically your administrative function. And that's how you carry out the enabling act into effect. So that would mean that like you follow the Open Meetings Act to conduct meetings and decide, what policies and what trends there are and what actions you need to take. And so that the public is fully aware of that, as well as practitioners. The other part is your judicial authority is often referred to as quasi-judicial. And that means that you do have the power to make findings of facts and conclusions of law and to make a decision. So it's very similar to kind of what you would think of as a court in the way they have to handle a case. It's just that since you're not lawyers, then it's called like a quasi-judicial. It's also administrative rather than a legal court. So, but in following your decisions for making these quasi-judicial decisions, you do have to follow the Kansas Administrative Procedures Act. That enables that everyone pretty much is all the cases are handled uniformly so that procedural safeguards are given to individuals. Your legislative authority is basically the ability to make law. So consequently, you have to go through a process that's established by the Rules and Regulations Filing Act. And once you have followed all of those procedures and it gets published, then they will have the force and effect of law. So that once they're properly adopted, if someone would violate a regulation, then you can use that to discipline someone. Sometimes they're not necessarily related to discipline. They may be more, definitions to clarify what's in the statutes. They could also be to set out more of what the coursework is that's needed for licensing. So they can have a full variety of, everything from getting a license to taking away the license again. We've kind of covered about the statutes and regulations, but we're going to go into a little bit more detail about what it takes to become a regulation. It can be quite lengthy. That's usually a question that people want to know is how long is it going to take? And that depends on whether it's going to be a temporary regulation or a permanent regulation. And our focus is going to be more on the permanent regulations because they are more lengthy. Right now, there's a procedure you have once you have gone through and drafted it and everything, it will go to the budget office right now, and they review it for the economic impact that it will have on the agency, on the state, and the licensees or the public. Then if they agree that it doesn't that it's within the economic impact, they will stamp the economic impact statement as well as a regulation to say they've reviewed it and approved it. It then goes on to the Department of Administration. There, the Department of Registration will review it to make sure that it is the correct style and the correct grammar, and so that all the regulations have some consistency in the way they look and in the way they read. After the Department of Administration then has stamped it as being approved, it will then go on to the Attorney General's office. The Attorney General's office reviews it for legality. Every regulation has what we refer to as a history section at the end, and there it has an authorizing statute and an implementing statute. Authorizing is pretty much just what it says. It will have language that says the board is hereby authorized to, and it can be very broad, which is to enact regulations to enforce, administer, interpret this licensing act. Or it could be very specific, which is that the board shall establish fees through rules and regulations for license, for applications and renewals and all of that. And so then that's specific. So it's only going to authorize you to do fees and nothing else. So the implementing statutes that we mentioned are in the history section are sometimes can be a little bit more difficult to discern, but usually the easiest way to think of that is that your implementing statute will have the same subject matter as the regulation. There has to be a connection between the content in the statute and the content that is in that regulation. If not, then we're going to have to say you're going to have to find another statute that you are trying to implement so that there is a connection. I kind of have stolen this. Probably David is getting tired of hearing this story, but from a predecessor, the way they kind of tried to make these two, the story, to make a visual of this is to say that the legislature through statutes created a corral. And they said you're authorized to put thoroughbreds in your corral. You're authorized to have regulations that say what it takes to be put in the corral and what it takes to remain in the corral and what will happen, what it takes for the board to throw you out of the corral. And so you would develop regulations that would say, well, thoroughbred horse has to go through so much training, win so many races to get into the corral. Then you say that after you're in the corral, then you have to continue your education on how to be a thoroughbred, that type of thing. Then you could say your other statutes are that once you quit winning races, you don't do your training, then we can throw you out of our corral. You're no longer a thoroughbred. However, that someone goes to the zoo, they see a zebra and they go, this looks an awful lot like our thoroughbred, 4 legs, a tail, a long neck. You know, there's a lot of similarities here. This is a unique animal we wanted into our thoroughbred corral. You can't do that because the legislature authorized you only to put zebras into your corral. And so you're going to be prohibited from doing that. And I mean, that's an oversimplification, but sometimes that's just gives you a little bit more visual effect of why you have these limitations on what you can and cannot do. So when you're thinking about adopting a regulation, the first one is, do we actually need it? Is it something that needs to guide applicants or licensee? So if it's already in the statute, you don't need a regulation because a regulation is not meant to repeat or just reword a statute. The other thing is it more self-directory, or we call self-regulating? Typically that means is the board is telling itself what to do. The board shall do X, Y, and Z, you know, upon getting an application. You don't need that because you don't direct yourself. The purpose of the regulation is to tell your applicants and your licensees what they have to do, what they have to comply with, not the board. So and usually when that happens, we're going to go back and tell them to rewrite it, because in almost all instances that language could be rewritten so that it's clear that it's directed to what an applicant or a licensee has to do. The other thing is this informational? Informational does not belong in a regulation because a regulation has the effect of law. So information does not have the effect of law. So it would have to go. And then again, the main thing is to remember what statutes that you have that gives you the authority to do that. So once you've gone through those steps of taking it to the Department of Budget, the Department of Administration, and the Attorney General's office, and everyone, and at any of those 3 points, someone could say, we're not going to approve this regulation as it is, and you will have to go back to the drawing board. If you can make corrections to the regulation, you make those corrections, and then you have to start the whole process over again. So that's why it can be rather lengthy, because of that process. But the reason is that you need to get these correct because they do have the force and effect of law, and you need to make sure that everything is where up to the standard it needs to be. So when it comes to AG's office, we're going to look at your authority to adopt that particular regulation and make sure it's within the scope of what you have in a statute to do, and make sure it also doesn't conflict with any statutes or with the Constitution. So make sure it's not vague. Usually things like vague that we see, it's like the secretary can require any other information in determining whether or not to grant this license. That doesn't give anyone any standards. That is basically opening themselves up to being arbitrary and capricious and making a decision. So you need to give the standards so that they know what is expected of them. So once you've got all the stamps, then the regulation is going to go over to the Secretary of State. Well, let me back up. Once you have all your stamps, then it will go to the Secretary of State, but what they will do then is they will publish all of that information, economic impact statement, the regulation, and a notice of hearing. The notice of hearing is for the public within 60 days, it has to be within 60 days of when it gets published, so that the public can go and give testimony on what they like or don't like about that regulation, or what recommendations they have for changes. Also during that 60 days, then the regulation is taken over to be considered by the Joint Committee on Rules and Regulations, and that is comprised of senators and representatives who will review it, and usually someone from the board is there to answer any questions that they may have. Sometimes that can be kind of a hot seat. Other times, it may, be rather neutral and not raise any issues. But usually after that hearing has happened with the Joint Committee, they're going to write a letter to the board if they had any concerns, asking you, are you going to address this? And the board needs to respond to that to make sure, because they want to know that you are listening to them. And the whole reason is why is because they feel you're not listening to them. Remember their power. They have the authority to take away that. So if it is within your power, they can, and this has happened, and they didn't want an agency to do something, they changed that statute so that you no longer have the authority to do something, which then makes that regulation that you work so hard on to not have any effect. So make sure that you address all of their concerns. After that, then after you've met with them, then it does go on to the public hearing. That is where people can come and voice their concerns. Then it goes back to the board. The board then is aware of what the Joint Committee had to say, of what the public had to say, and they have to make a decision then. Do we need to amend this regulation to address what we have heard in the feedback that we've gotten? Do we need to tweak it just a little bit? If it's going to require substantive changes, then the whole process starts over again. If they're just little tweaks, typically you still have to get those tweaks approved, but you probably will not have to go through the whole process again. So then to make it into law, the next thing is the board has to vote on it, and the board members will take an individual vote. It's it's a roll call vote, and that is recorded. The roll call vote is certified. The certification and the regulations taken back to the Secretary of State, who publishes it. Once it is published, then it will become laws 15 days after publication in the Kansas Register for a permanent one. A temporary regulation is, like I said before, is a little bit different. It's the same process. You still have to go through those 3 different agencies to get everything, all your approval stamps, but it will not go to the Joint Committee. Instead, it will go to the Rules and Regulations Board. And that is a little bit different. That board the Joint Committee has no authority to stop you from adopting the regulation and making it become law. However, the board does for the temporary regulations. They cannot approve it. If they don't approve it, then it's done. It won't get published and it won't become law. But if they do approve it, then it's approval by the state rule and then getting it filed with the Secretary of State. Permanent, like I said, it's permanent. However, temporary regulation is only good for 180 days. That's why if you're going to have something that needs to be in effect rather quickly, it's usually because the legislature's given you a certain date to get something, and that may not be accomplished in time. You're going to run temporary and permanent regulations together at the same time. Then when you get the temporary regulation, you will continue to work on your permanent regulation. And if anything needs to be tweaked in the permanent, then you come back within that 180 days. If you can't get a permanent approved in that 180 days, you can go back and ask to renew the temporary regulation. But that is going to be like probably pushing a boulder up a steep hill. It's very difficult to do. You're going to have to really explain why that permanent reg did not get done. Another thing that sometimes is a little bit more concerning than a regulation is our policies and guidance documents. Policies are adopted by a board to guide the internal operations. So it's usually going to be directed towards staff on how they need to proceed to do something. Typically, you're going to see policies that will be your open records policy that will say, you know, if we get an open records request, then it goes to the custodian of records. They make a determination on the request and handle it and get, you know, search for it and all this stuff. And so it explains to the staff how to handle it, but it also explains it to the public how to do it. You have an open records policy. It's one that's decades old, but it's still there. And it is on the board's website so that the people can look at that. Another policy that is like your investigative committee that will say, like, when a complaint comes in, this is how that complaint is handled. So that way persons who want to file a complaint, or even for someone who has a complaint filed against them, can go on the board's website, see its policy, and have an idea then of what's going to happen once that complaint gets filed. Guidance documents are different. They are addressed in the Rules and Regulation Filing Act, and they have certain ways you have to do them. They are, in essence, guidance documents are more for the people that you regulate, such as applicants and licensees. They don't go through the procedure that a regulation does, and they do not become law. Nevertheless, you do have to file them. We can go through the process a little bit more, and then you have to publish them on the agency's website. What makes them a little bit different is that they can be called precedent in any cases that you would have before the board. And if you decide not to follow your guidance document, then you've got to explain why. So you need to be very careful in handling guidance documents to make sure if you go through that, you do go through the process, and then remembering that once you've done that, you need to be able to address it in your cases. Now, that effectiveness as a board member, even an advisory committee member, are to be very aware of your statutes and regulations and your enabling act. Your enabling act begins at 74-7501, and those statutes will tell how the board was created and what their powers and authority are. Then you have about 7, am I right? 1, 2, 3, 4, 5, 6, 7, about 8 licensure acts. There's similarities, but they're also different. So you need to read all of, as a board, the board members need to read all of those licensure acts so that they're familiar with them, and reread them as necessary, especially if you have a case or an issue pending about that particular act. The other thing that you have are regulations. There's not a set of regulations that covers all of the licensing acts. Rather, each licensing act has its own set of regulations. So in addition to reading each act, you also need to read each regulation that goes with the act so that you have a full understanding of the whole complex structure for that license, for that particular profession. You also need to be aware of the agency policies and internal procedures that might not be consistent with what your statutes and your regulations say, or that could affect the requirements that you have placed on applicants and rationale. What will make an attorney cringe is the response of, "We've always done it this way." It's not a legal defense. So consequently, that's why you do need to be aware of what the statutes and the regulations say, and make sure that if there's any doubt about the legality on the way you're handling anything, that you consult with your assistant attorney so that you know if you're operating within the bounds that you have. You also may find out that there's a need to amend a statute or a regulation. So consequently, if it's a statute, then you have to develop a legislative packet, take it over to the legislature to get it filed. Then once it goes through that legislative process, to get it and then signed by the governor to make sure that it will become law. Again, and then a regulation, you can always amend the regulations, and that happens very frequently to keep them updated with current practice and procedures. So if you are reading a statute or regulations and it goes, this doesn't make sense to me, it seems overly burdensome, then probably the public and the licensees may feel the same way. And that's when it maybe becomes when you need to say, maybe we need to take another look at this again to see if we need to make changes. And then again, but remember, when you're making anything new or any changes or disciplining a licensee, it's always complying with the law and protecting the public, making sure that you are not imposing something that's too harsh, but it's to protect the public. The other thing board members and advisory committees members need to be aware of is a conflict of interest. And this is because as committee members or board members, typically you don't wear just one hat. You're going to wear several hats. So you have, as a board member or an advisory committee, you have that hat. You're going to have licenses. So you need to, that's another hat, is as a licensee. And then you may belong to a professional association, and you may be active in that professional association or even be on their board. So that's another hat you wear. You may also be an employer who employs licensees. So that's even yet another hat you would have. Or you may be a professor at a university, so yet that is another hat. So consequently, when you come to the board, though, or to the advisory committee, you have to take off all those hats. And the only one you can wear when you're doing board business is the board hat or the advisory committee hat, because your interests there may not align with all those other hats. Because as you know, I keep saying, your role is to protect the public, and that is what your role. Your role is not to protect licensees. It's not to advance the interest of some professional association. If professional associations believe that there's something the board needs to address, again, then this is something that the board member doesn't represent them. Instead, that association would come to the board and they would present it, so that way you are keeping clear of which hat you were wearing when you were before the board. If you do have a conflict, then you need to let the board aware of the conflict, and you also need to abstain. So that would mean that you don't participate in this discussion, or if you have anything to say, make sure that everyone understands this is me, not as a board member. If there's votes, then you would abstain from the voting. So always be very, as I said, be very mindful of which hat you have on when you're there for the board's business. Because I can tell you that will make the public very frustrated if they feel that they know that you are doing one role, and when you come to do the board business, they feel that you've crossed over the line. Sometimes, you don't, but it can be the perception of that. So that's why you need to be mindful even that you don't give that perception that you're operating or making a decision based on something else. So there can be a conflict of interest, not just in your role that you have, but it may be other things more personal, such as a monetary benefit, a personal gain. Is this going to somehow take a competitor out of my way? And so I'll have more business. That would be another thing. Other thing is more personal, is it say an application or complaint would involve a friend or a relative, so that you have some bias or some knowledge about it that is not coming through that to other board members. You need to stay out of those kind of situations. If somehow you know the people involved, that you think you cannot set aside those biases. You may even have to tell them that you have those biases so that they know why you're not going to participate. Let's see, confidentiality, as board members typically will come into confidential information, not so much perhaps for advisory committees because you're not really acting in that same capacity. But usually the protected information will come through executive sessions or dealing with applications or discipline. So once you have that protected information, it doesn't just stay with you while you're on the advisory committee or while you were a board member. It stays forever unless that would somehow be waived. So you have to keep that confidentiality for the whole time. So executive sessions for licensing boards are typically only, there's a myriad of reasons why you can go into executive session, but for licensing boards, there's typically only two. And one is to get legal advice from your counsel, which is going to be an assistant attorney general. You have not hired our outside counsel, so it's going to be someone from the attorney general's office. And the reason for that is to protect the attorney-client privilege. So we're there to answer legal questions or to give you legal advice. But what happens to take the executive session has to be done by motion. The motions have to state certain things in them. And then once that has been met, only the board members and the attorney are into executive session typically. However, staff may be included as a part of the client. Or someone else may be included as a fact witness. They may come in for a very short duration to give information to the board, then they will leave so that the attorney-client part can happen. The advice can be given. But so the main thing you need to remember though, because those are private, it's advice that you are giving to someone, that when you come out then in an open meeting, don't start discussing what happened in an executive session. That just sort of blows the whole rationale behind it. And what is likely to happen is you could see someone filing a coma complaint, saying if they're going to come out and say what happened in executive session, there was no need for it. And so they could have just had the discussion out in open session. So remember, when you come out of executive session, you can make a motion based on what may have occurred, but you don't discuss the legal advice so that it's out in the open again. If the legal advice or anything in that consultation needs to be waived, a board member cannot waive it. It is a majority of the board. So consequently, you would have to have an open meeting, have that discussion about whether you don't say what is there that you discuss in executive session, but you would have to take a vote on whether or not you want to waive the attorney-client privilege for that particular executive session. The other thing that for executive session besides attorneys is usually for legal consultation will be for personnel matters, and that's to protect the privacy of the personnel because a lot of times things are said that aren't true and you're trying to decide what happened, what didn't happen. It's to protect them and also protect the board, make sure you don't get sued for defamation or something. The board will use both of those, but for an advisory committee, probably the only one thing might be is going to be for legal advice. Deliberations after a hearing are considered quasi-judicial deliberations. That's not an executive session motion. If it would occur during an open meeting, there is a particular statute in the Opens Meeting Act that says that quasi-judicial deliberations are not a part of a meeting or not a part of the act. So that's why, and even in an open meeting, quasi-judicial deliberations are there, but you have to be discussing the facts of a case and what the law is and applying the law and then you come out and you would make the decision. CAPA, though, is for the board, you have recently changed, I think 2016, you went through and changed all of your acts so that you are now have everything under the Administrative Procedure Act for applications and for complaints. So consequently, that gives you the authority then to discuss a lot of things. The only thing under the Administrative Procedure Act that has to be open to the public is the hearing itself. And then, of course, you can close it if you're going to discuss confidential information, such as medical records. But other than that, everything else is not necessarily open to the public. It's up to the board or to the investigative committee if they want to make anything open. Ex parte communications. Typically, this is going to happen when you are considering, when the board is considering applications and discipline. So if you, ex parte just means that you are having a discussion about a specific matter with someone else who is not a party or is not the attorney for the parties, and the other person is not there. So it's like you are getting information in secret that one of the other parties would not be privy to, or maybe no party would be privy to. And so you have this information, but they don't, or at least one of them doesn't. And that's what makes it ex parte. It is prohibited under the Administrative Procedure Act. It says if it happens, though, you have to make known that, put it in the record that you had an ex parte communication, and let the parties and the attorneys know that you had that ex parte communication. Then you would also have to decide if you can continue to be fair and objective. If not, you need to recuse yourself. But even if you don't recuse yourself, then you may have a party asking for you to no longer be, to recuse yourself. That then creates an issue of whether or not you should have taken any further part after that ex parte communication. Sometimes it can happen just out of the blue. You're someplace, you run into a licensee and they go, oh, by the way, did you know, you remember Joe Smith we went to college with? He's got a complaint against him. I understand. I hear that this and this happened. So then consequently, now you've had ex parte communication. So you need to be very careful. Someone wants to start talking about board information, you kind of raise it and stop. I can't hear this as a board member. I can't have conversations without the people here, and I can't participate. So sometimes that can be kind of good, because then you don't get yourself into conversations that you don't want to be a part of. Another way that you may end up with ex parte communications is you do go to a social function, a professional association, and there are licensees there, and they may come up and start talking to you about board business. And then you need to say, hold on, if it's about a specific case, I can't discuss it. I can't discuss any pending cases before the board, or even if it's just about board business, you need to be very careful. If it's not about a specific applicant or licensee, you need to be careful, because if there are other board members there and you have a majority of board members there, even though you may not think about it, if you start to engage in discussion of the board business, you may then have yourself open up to an open meetings complaint. So you need to be very careful of those ex parte communications and having discussions at places other than a board meeting. Again, we talked a little bit about professional associations, so be careful to keep those two roles separate. That the board is to further the interest of the public, and the professional associations is to further the interest of the licensees. There's nothing to prohibit you from attending the professional conferences and social events, but you just need to make sure that you have in mind all the different ways that you can walk into an issue that you don't want to create. The other thing is typically what happen is that if you're asked to speak someplace, you have to make sure that if you're going to speak, whether it be at a Kwanzaa Club meeting or professional association meeting or over at the legislature, that you make sure that they understand that you are speaking there in your individual capacity and not as a board member. To speak on behalf of the board. To speak on behalf of the board has to designate you as the person who has the authority to talk to that particular group and to express the board's position. So if the board doesn't do that authorization, you're there on your own individual capacity. The COMA, which is Kansas Open Meetings Law, is something that every board member and a public and the advisory committees needs to have a pretty good understanding of, because a violation can be pretty devastating. The open meeting laws is to make sure that the public can go and observe and see what the business of the board is and what you're doing, because our whole system of government is based upon an informed electorate. So that's why they need to make sure that they can attend it and listen to it. The act is to be liberally interpreted, and the exceptions to the COMA are to be narrowly applied, so that way it gives the full, that the purpose of it is given the maximum benefit. COMA is going to apply to like all legislative and administrative bodies and the subdivisions, so consequent and subordinate groups. So that's why the board is there. And because the board has created advisory committees, that's how the advisory committees are brought in, because you are a subordinate group of the agency. In essence, as an advisory group, you have become an extension of the board, and you are basically receiving benefits from them, funding from the board. They provide you staff, they provide you a place and a means to meet. So that is the important thing. You need to understand why you are basically under the umbrella of the board. So what is a meeting? So it's basically any gathering or assembly of the board members, and that can be in person through the use of a telephone or any other medium that allows for interactive communication. So your conference call, you can have meetings conference call, you can have it through YouTube, you can have it through video conferencing such as Zoom. However, there has to be a majority of the membership of that public body subject to the act. So like for the board, 12 members, then a majority is going to be 7. If you don't have that majority, then you are not in a meeting. You can sit there and have a discussion, but you can't do anything. So, you know, once you can't gather that majority up, usually your meetings are closed. Same thing for the advisory committees. If you've got 10 people on the advisory committee, then it was going to take 6 people. And we're not talking about the number of people that show up for the meeting. It's not a majority of the ones who show up. It's the majority of the people of the number that belong on that particular group. So if the legislature's put 12 members on there, then it's a majority of 12. If the board has put 10 members on an advisory committee, then that is the majority of 10 that has to be there. And it doesn't really matter what you call this get together. You'll often see agencies refer to work sessions and retreats. That doesn't matter. They're still subject to the open meetings law. As long as the meeting is reaching a majority of the people or majority of the members, then they're there to discuss board business, then that makes it a meeting. And it doesn't mean it's a discussion of the business. So it doesn't require that they take any action even. So just the fact that you didn't do any motions and take any actions won't matter as long as you discuss something. A lot of times people also get caught up on a quorum. And I think this is probably some statutes every now and then will use a quorum, but the open meetings law used to say that a meeting occurred when they had a quorum of a majority. So example, again, if you have a board that has 12 members, a majority is 7, but a quorum of the majority then it gets down to 4. So consequently, 4 people out of a 12-member board would constitute a majority, and they could act. So you have less than half the people there, but that would be a quorum of majority, and they could take action. So they took out the language several years ago about a quorum, and so now it's just a simple majority to take action unless you have a statute that would say something different. The presiding officer is the duty to provide notice of the meeting. Typically, however, that's delegated, so that's usually why someone on staff sends out the notice of the meeting. Anyone can ask for notice of the board's meetings or even the committee meetings, and if they do, then you have to give them that notice. It's to tell them when and how you're meeting and how they can attend. They have to request the notice in order to get it. That can be verbal or written, but most of the time you're going to want to get it in writing so that you have the right name and how they want to give it, if it's by mail or if it's by email. The board does their kind of a generic notice on an email, and it kind of goes out like a shotgun effect. Everyone gets the same thing at the same time, and it will have all the meetings for the board and for all of the advisory committees. A request is valid only for a fiscal year. The board does have the authority, though, to notify a requester before the expiration of that fiscal year and say, you know, your fiscal year's up. If you want to continue to receive notice, then you need to tell us that. If not, we're going to drop you off of our notice. But if you don't go through that, then you cannot drop anyone off until you've gone through that procedure. So a lot of times then you're going to see in June that email go out to everyone and say, you've got to tell us if you want to remain on this notice. The other thing that people usually have is, especially new members, is like, okay, what are we following to conduct our meetings? Are we following Robert's Rule of Order or something else? And the answer to that, the board can adopt a Robert's Rule, but it's not a good idea because a lot of those are very formalistic. It limits you to how and when you can do things, which could cut into your effectiveness as a board. You want to have some very liberal so that people feel that, you know, if an issue comes up that they can make that motion or they can revisit it, which they may be not able to do. Not only that, but most people don't know their Robert's Rule. And so if they have questions about can we do this, you know, what's the next step? That's not asking for legal advice. Robert's Rules are not statutes, so I don't know. And that's up. And besides that, I believe under Robert's Rule, you have a parliamentarian, and that is the person who you go to. So if you haven't done that, then you don't know. Those are not necessary. I'm not so sure there's very many boards who have gone out and adopted any type of formal procedure rule book. So the public, you do have public comment. You're not required to have public comment. That's entirely discretionary with the board or with the advisory committee if they want to have public comment. Because otherwise all they can do is to listen and observe. If you do allow the public to speak, you can also limit to how long they can speak so that way you can get through what you have on your agenda. The public cannot be disruptive. So if someone does get disruptive, then you can have them excluded from the meeting. Usually that doesn't happen so much at board meetings. You see that a lot happening at local government levels, a city council or county council, where things get a little bit more impassioned and someone may have to be asked to leave. You are not required to have minutes of your meetings except when you do an executive session. When you take an executive session, then that executive session motion has to be recorded pretty much verbatim in your minutes. So consequently, that way there is a record to make sure that you followed everything the statute requires for an executive session. To take the executive session, you have to be in an open meeting to do that. And you do not take binding action in an executive session, but you can do a consensus, which just means that you think you know what you want to do. When you come out, then you make a motion if you want to take action. And that is when you do a formal vote. When you vote, you cannot do what is called a secret ballot, which means that you would take a little piece of paper and you would vote, put your vote on there and then hand it in. And then like the chair would then open it up and tally up the votes. That's a secret ballot. You cannot do that. There is one old AG opinion that addresses secret ballots, but I would suggest that you not follow it. I think it would get you in trouble. I don't think that anyone, a district court would probably follow this anymore. And because of changes in the law a little bit, and the problem with having to be open, that there's always that presumption of openness. But what that old AG opinion said was that you could use secret ballots if they put their yes or no vote and if they signed it. And then if someone wanted to see how a particular board member voted, they could come in and make a core request and they could look at those things. Well, that's not making an open meeting that the public can observe if you're going to require them to go make a core request and go into the office. I don't think that's going to comply. So don't do that. Just stay away from secret ballots, and just remember your duty as a board member is the openness. Not only that, but it means then that you have now created records that are subject then to your disposition form that you have, the procedures you have to follow to get rid of those. And you've got all these little pieces of paper then you've got to keep, that executive director has to keep, and it's not good. Executive sessions are governed by statute, and so consequently it puts all the requirements on what has to go into executive session. And so you have to follow it. The statute does say what the justifications are for closing the meeting. And we discussed a couple of those, which is attorney-client discussions, and also to discuss personnel matters. Then you also have to have a description of what's going to be discussed, but you can't reveal what the confidential information is. Otherwise, you've just kind of blown it. So putting in the subject can be a little bit trickier. Then you also have to put in the time and place then that the meeting is going to be resumed. And then that motion has to be recorded in the minutes and permanently retained by the board. The complaints can be filed with the DA's office, county attorney, or the attorney general's office. The complaints that you're going to see most often involve executive session motions, improper motions for executive sessions, that they took too long for the executive session. They didn't come back when they said they did, and failure to give notice of the meetings. Another one is serial communications. And so maybe we need to discuss those a little bit. Serial communications are when you are not in a board meeting, but perhaps you have telephone calls or emails among the board members or among the advisory committee members. And if you are discussing the business of the board in those emails, once it reaches that majority, even at that point, that can trigger a coma violation. So when you get like an email that says reply, about something, if it says, it should say at the top, informational purposes only, do not reply all, do not forward, do not discuss this email, until we're in an open meeting. So that is very important, that once you get those kind of things, don't start hitting reply all and saying, hey, this is what I think about this, and then because other people then start to do that reply, and pretty soon you're going to get a coma violation. It's the same way with telephone calls. They're referred to as like a calling tree. And that would be one person would go call one board member and they go, hey, here's this, what do you think about it? And they go, okay, thanks. Then they call another board member and they go, hey, this is going on. This is what Sally thinks. How about you? And they go around to each board member, get their viewpoint, and then they tally up what they heard and take action. So telephone calls, emails are typical things that are referred to them as a serial communication. So be very careful in emails and telephone conversations. Prosecutions it's a civil prosecution, it's not a criminal. Prosecutors, other than a private person, does have the authority to have a subpoena power, which means they can subpoena over your records so that they can get all of those emails if they need them, or letters, any type of other communication that you had. They can also, if the complaint is filed quick enough, they can also stop any type of action that was taken, or they can ask for an injunction or a mandamus or just a declaratory judgment. Okay, so if you're falling asleep, this is when you kind of need to perk up, because this is the violations for COMA. If you violated it, the penalty can be $500 per board member per violation. So if you committed more than one violation at a meeting, so that then say there's 2 violations, then you could be at the total maximum could be $1,000. And please note that I said per board member or per advisory committee member, because what that means is that it's the board does not pay the violation. It's the person who pays it. And so consequently, that's why it's important to, to be very cognizant of what the COMA says you can and cannot do, because you don't want to do that. It's also possible in a very serious situation where you could be ousted from office, or if you're an elected position, to even be recalled. Now then, I said that and hopefully got your attention, but remember, that's the extreme. The things to maybe consider, they can also assess court cost, and in certain instances where it was pretty egregious, attorney's fees. So be very careful about that. Most likely they don't have to assess a fine, or what they can also do is to have you go to training. That's why we have this training. The training that you would go to, though, like what the AG office gives, it has to be approved by our office. It's usually much more detailed, much more intense, even lasts longer, because it is only about COMA or COMA, if that was a COMA violation. So what you would hope for is you do have to, if you get notice of that complaint being made, to respond to it, to be straightforward. Don't try and play games, and don't lie, because that's one of the things they can see. If they can see that it was not a willful violation, that it was just a trip up, or not having the training or the education, those are the kind of things, those are the discretionary facts that they take into fact to decide they don't need that $500. The Attorney General's about 5-6 years ago was also given the authority to do what's called a consent agreement. So it's pretty much like what a board would do, where you reach out and do a consent agreement order with someone else. It will have findings of, they're going to require you to admit or to stipulate to certain facts. That is how they get the violation, and then they can require you to do the training, and they can also impose a penalty. But here, the penalty is a little bit less. It's $250 for each violation. They can also require you then to say that you're going to agree you're not going to violate the COMA anymore. And then you will be required to personally sign that order, so that it will have that on there. Let's see. One other thing that is in here for the COMA, as I said, well, no, this is going to, let me back up. We'll cover that. It's more CORA. So that is why make sure what hat you're wearing and who you're talking to. And if it's board members or staff is not subject to COMA, only the board members and advisory committee members are. So the fact that so staff is not counted in that majority, and they don't violate the act. So don't rely on them to keep you out of it. Always make sure you're thinking for yourself. Open records policy is pretty much It's very similar to the coma in that it is to be construed broadly to give the maximum openness to the public. Only thing is it involves records. It's the board records. And so once someone can make a core request saying, hey, I want these records, the board has to look, see if they have those records. They do a search. If so, then within 3 days, they've got to respond back and say, we don't have any records, or, you have an extensive search. So we're going to have to take some time to find the records, or yeah, this was really easy to find. Here's your records. It can be any recorded in a record is very broadly. So it's not necessarily a paper record. It can be any type of recording. So it can be an email, it can be data that's stored on the computer, it can be photographs, it can be a book, it can be a video, all of that. So it has to be related to what the board does. If there is not a record, you're not required to create one. It's the records that are in existence when you receive that core request. A core does require that the agency have a Freedom of Information officer who assists with core requests, and that you have a brochure that describes your policies and the rights of a requester. And then the records custodian, and to tell what your fees are for handling a core request. And if someone wants to come in and inspect it rather than get a copy of it, the hours that you're available to do that. You can charge the fees for this. So if they want to come in and look at it, then you can have staff sit there with them and look at it to make sure that they don't do anything to it and that you can maintain it. You can charge them for that staff time to do that. If you have to go research records and pull them and copy them and redact them and mail them out, then you can charge them for all of those fees as well. You do have the right to close certain records, such as if there's a state or federal law that says these are not to be disclosed. The copyrighted materials is one thing that you cannot print. They can come into the office and read copyrighted material, but you cannot copy it. So that is why you would write back the letter that says we have it, but it's copyrighted. It's not our copyright, so we can't give you a photocopy of it. Another one is social security numbers, personal identifying information, that type of thing. It can be redacted and then the rest of the document can be given to them. So that is why it can be rather extensive if there's a lot of redacted material in there that staff has to go back and eliminate and then copy it without that information in it. Some of the things that you can close out are going to be like medical records, psychological records, treatment records that pertain to an identifiable patient. So that's kind of the key. Is it just more in general, or is it, can you tell who the patient is? Personnel records, except for you can give out the employee's name, position, title, and salary, or a contract that you have and their length of service. Anything that goes beyond that, such as discipline, that's an unwarranted invasion of property, and they can be closed out. Unless, of course, there's some type of consent that is given. Typically, we're going to core, we'll look at other statutes because there may be exceptions to the statutes that authorize closure may be found in an act other than core. So you're going to look at those other acts first to see if there's something, and then you can look to core to see if core says that you can close it. If you do close something, then when the record goes out to them, you're going to have like a transmittal letter to explain why certain documents were not given to them or why certain documents were redacted, and the legal authorities to do that. And core, like coma, is a civil act. It's not a criminal act, and it can be brought by any person or a county or district attorney or the attorney general's office. Core requests also can be reviewed by the district court in camera. So if you have closed something, you don't want to put that in there on the public records. So consequently, you would give it like a sealed document to the court. They would review that in camera, and then they would decide if you were correct in your analysis that there is a legal basis to close that and that you did close it correctly. So, again, costs for not giving someone the records can be assessed. There's fines up to $500. Also, again, attorney's fees could be included if they determine that the denial was made in bad faith or without any basis in fact and law. This particular fine would, or in these costs, they go against the board. So here it is not the individual board members. And why? Because it's not really in these type of situations that the board is making a decision. It's usually staff that goes through the records and makes these decisions. So it's usually going to be incumbent upon staff. That's why it's incumbent upon staff to be really careful when they get these core requests. Because it's going to come out of the board's funds if there's an error. The Attorney General's office, as we stated, is someone also that can enforce it. And again, about 5 or 6 years ago, they got additional authority to do a consent order. One other thing that they have is that they can do with their subpoena power. They have it used to be that under the core, the way it was defined as to what a record was, it was anything that was stored on like the state's record. So consequently, emails, if you had a private email, those were not a part of the board's server. So they weren't stored on the board's records. And it became kind of problematic because they realized that there were certain individuals who were subject to core that were using their private emails to discuss business. Now you can have a board email address that is on a state server, but those can be rather costly. Some agencies do have that. They think it's worth doing that, but then you have to remember that when you're discussing board business, always to use that email address and not your private email address. But if you're using your private email address, that can create a problem if your emails are going to that private email, because now, as I said, there's that subpoena power to go after the records, so they can now go on your private server. They defined that it doesn't matter where that information is stored, so it doesn't have to be on a state server anymore. It can be on a private server. They have the authority to go in and do a search to find those emails to see if you violated CORA. So how do you get around that? The simplest way is to make sure that on all your emails about board business that you include a staff member, and it's probably going to be Dave. So you would include him as a CC, and then that way, when they go to do the search, it will pop up under Dave's email address, and they can see if there was a core violation because there was discussion going on in emails. But if you start to use your private emails thinking you're going to get out of Quora, you need to be aware, because it's not going to work now. They can go in and find that. And all it takes is that someone in it somehow finds that email and they realize that something's gone on private emails, and they're going to come looking for you. Let's see. Again, they can do cease and desist actions, telling you to stop doing that. You have to go to training. You can have, again, a $500 for each violation. Go to have compliance because you're not complying with CORA. I should say something else because you're about emails, because emails are subject to CORA. When you do use emails, always make sure that you keep them very professional, because a lot of times you know people personally and you may make a snarky comment. Even I am probably guilty of that from time to time. But you need to or that you get mad, like, how can this licensee believe that? This is just crazy for someone to believe this. How can they not understand they didn't make this violation? Because what's going to happen? Someone's going to make a core request that snags that email. And if there's no basis in law to redact that or not disclose that email, it's going to have to be handed over. What happens then is that person sees their email either in litigation or on the front page of the Kansas City Star, the Topeka Capital Journal, or the Wichita Eagle. And if you think it won't happen, it has happened. Someone becomes very embarrassed because of what they put in an email. But if you keep it very professional, you don't have to worry about that. Even if they don't make a core request, if it's something that's pending, like a discipline case or an applicant case, discovery can be made, and they can then find that comment through discovery. Okay. So the Kansas Administrative Procedure Act, that's typically the process, as we said, the procedures that you have to follow when you are looking for how to handle an application and a discipline. And the reason the advisory committee probably isn't going to handle anything like that is because you're not a presiding officer under the Administrative Procedure Act. They have a definition for what a presiding officer is, and that is basically a board member or someone on the board that has been delegated the authority to be a presiding officer in certain things. So consequently, they can't give the advisory board members anything to do with applications or discipline, in that regard. And if they did, then you have that. If you remember, go back, we were talking about ex parte communications. That could become an ex parte communications because they're talking about it with someone who's not another presiding officer or someone who's not the licensee or the applicant or their attorney. So now they've opened themselves up to a problem with an ex parte communication. And I won't go through. So again, all of your licensure acts have the same language for your CAPA proceedings, which is administrative proceedings and disciplinary actions regarding licensure under the whichever act shall be conducted in accordance with the Kansas Administrative Procedure Act. The only act that you have that doesn't have that language is found in the Behavior Analyst Licensure Act, and it's a little different. So if anything comes up under that act, you need to be aware of that because it says any action taken under this section which affects any license or imposes any administrative penalty shall be taken only after notice and an opportunity for a hearing conducted in accordance with the Kansas Procedures Act. So consequently, things that happen before you do that may be under coma. That's an issue that would have to be taken up at that time if that language remains as is without any changes. Under the CAPA, as I said before, only thing that's open to public is the hearing, but they don't, the notice, the public can't say, hey, here's my notice, I want to be notified of this hearing. Well, because it's not under the open meeting law, they don't get notice. They can always ask and say, when's the hearing? And you could notify, you could let them know so that they can attend, but they don't, the notice provisions in COMA do not apply. So typically when the board is considering what to do with the case, the public and the licensee, not even the licensee or the applicant are there. The only way they would be there is if they are asked to attend, or if we get to the point of perhaps where there's going to be a pre-hearing conference or the hearing itself. So CAPA will not apply to where you're talking about the board's minutes for meetings, whether to approve or amend regulations, guidance documents, or what giving any authority to the staff, contracts, anything like that, or any policy decision. Those are all open meetings. As budgets are another one that's open meetings. CAPA, the easiest way to try and figure out if you're under CAPA, because CAPA will involve an identifiable specific person who has an application or a discipline matter that is pending. If it doesn't fall within that, then you're probably not going to be under CAPA, and you need to be very careful because it's most likely going to put you under COMA. We're taking a little bit long here so we can kind of skip over, since the advisory committee isn't subject to to the Administrative Procedure Act, and the board members, I think on this pretty much kind of have a little bit of a feeling now for how the CAPA operates. They've done some delegation motions recently that sets up who can be presiding officer in certain instances. They've set up the CRC, which is a complaint review committee, to handle the discipline matters, when they receive a complaint. And however, though, like for applications, the full board still makes those decisions. And again, then there's a process that they go through for doing orders. The one thing to think about is that once you've made a final decision, it can be appealed then to district court. However, the appeal is really very limited. So it's not like they get a whole new hearing before district court. Instead, all the district court will do is to review the entire agency record for the matter and then the decision. And they're going to be looking for those legal reasons to see if you complied or didn't comply. Some of them, one's unconstitutionality or interpretation of a statute, it happens once in a while, but not so much. Usually, and then why we did the delegation motions was to make sure that you have the prescribed procedure in place as to who can do what and who is constituted to make that decision. The other reason that usually they apply, the biggest number one reason is that the agency action, which is the decision or order that was issued, was made on a determination fact that was not supported by the evidence that's substantial when viewed as the light of the record as a whole. So that's why when you're making decisions, you can't look at just a small portion of it. You've got to look at everything. And so your final order really needs to address all those facts so that way the district court goes, yeah, they had that before them and they knew they had that before them because it was in their findings of fact. But when they got down to applying those facts to the law, this is what they determined were the relevant facts to show a violation or to show someone was not qualified. And that was the basis for the decision. And so that decision was lawful based upon the facts that they made, that was on the record as a whole, and that they had that lawful authority under the statute. The other one that's just kind of a Hail Mary that gets thrown in, if they're going to appeal, they're going to throw this one in. And that is that the action was unreasonable, arbitrary, or capricious. And so if you had the statutory authority and you had the factual basis, that pretty much gets thrown out. The only other time that works is if you had the may and you used a shall. It's arbitrary when you have a discretion and you don't use it, then courts have said that's the unreasonable, arbitrary, and capricious. So that's why if you ever have a question on if you have sufficient facts to take the action or if it's legal to take that action, to consult with legal counsel. Okay, so the last act we're going to talk about is the Kansas Tort Claims Act. This covers, it uses the word employee, but the definition of employee will include a member of a board or committee of the board. So that's why the advisory committees are all under the Kansas Tort Claims Act. But you have to be under it. It's very important. You have to be basically acting on behalf of the board in an official capacity. It doesn't matter whether you're getting compensated or not. So this kind of loops back into the very beginning of what we said. That's why I'm trying to tie it back in, is because you're going to be covered under the Kansas Tort Claims Act if you had that statutory authority as a board member, as an advisory committee, that you were doing what you were authorized to do. So consequently, it's not going to cover, if you get in a car accident and get sued, you're not going to be covered. It's what you do as a board member or an advisory committee member does. The other thing, there is some immunity in that if you are acting within that scope and that you are doing that. So this is where it becomes important to know your shall and your may, because if you had discretion and didn't use it, then that's a problem. Or if you had a shall and you used a may, so consequently you weren't acting accordingly, like you gave someone a waiver and you didn't have the authority to give any a waiver because it was a shall, then you may have that problem. what happens, so if you do get sued for something that you do as a board member or advisory committee member, is that you need to immediately notify the Attorney General's office and ask for representation. So you will make that request and send within 15 days after you've been served, give us a copy of the petition and summons, and then cooperate in your defense. So as long as we have that, and then we will look at everything and it looks like that you did, you did everything, that you were not acting with actual malice or fraud, and then that gets you within the representation. And the other thing that could come into effect is if you ask for legal advice from the Attorney General's office and they say, don't do this, this is something that's clearly a violation. Don't do it, because if there's a complaint, you're going to lose. And you go, I don't care, I'm going to do it anyway. One, that would be more willful. And so you could be getting into that maliciousness, but also what we could do is to say, we're not going to give you that representation because you were told not to do this by our office. So it's not that it's blackmail. It's just that you can't have your cake and eat it too. So, if we give you the representation and the legal advice and you don't understand it, then, ask us so that we can explain it better, so that you have a clear understanding of why that advice is being given. And it could be in that, yeah, maybe we said don't do this, but what has happened is it becomes a gray area. And that could be something that happens, or sometimes there's an intervening change in the law or an interpretation by an appellate court that would go the other way. That's kind of that gray area where it's subject to interpretation until an appellate court determines what it means. And in that instance, that's not something that you did. In addition, if we tell you to take some action and you follow our advice, then, and it happens to be wrong, then that mitigates what could happen. So they could say, well, you weren't acting in bad faith. It wasn't something you did intentionally. You were following your legal counsel. And so it could mitigate damages. So that's, again, just was not in a nutshell. I'm sorry for that, but hopefully it gives you a little bit of understanding of why there's so much to think about when you're a board member or on an advisory committee, because there's even more acts that are applicable, but I didn't go into them. These are usually the biggies that kind of people get hung up on. Any questions? Or everyone fell asleep or went off to go get a little snack while I was talking.
It's a lot to absorb.
Yeah, and that's kind of why we put it out I put it out in a handout, because if you can
Yeah,
always
it's
go
very
back
nice.
and look at that if you have
Read
any
it.
more questions.
Mhm. Thank you for that thorough, report.
You're welcome. So I guess if there's no questions, if you want to go on.
And Carolyn, do you want me to, oh, sorry.
Go ahead, David.
I was going to say, do you want me to speak to the next item on the agenda?
Sure, that would be great.
So the next item on the agenda is a scheduled executive session. And I have language for a motion for executive session that I could go ahead and read. And then if a member of the advisory committee wanted to make that motion, I'd be happy to go ahead and just read the motion and someone could adopt it by saying that they're in favor of that motion. For the executive session, all I need is a certain length of time for the executive session to take place. And then I can include that in the executive session and the time that the advisory committee will be coming back from that session.
Dave, we only have 4 committee members now. Someone left.
Okay. Yeah, it looks like right now we have
4. 5
board-
people, but I don't think one of them is a board member or advisory member.
Yeah, is there any individual who's on the conference call line right now? Okay, it doesn't sound like there are. There are 9 members of the advisory committee, and it would take 5 to have a majority. So right now, it looks like on the Zoom call, there are 4. So if there was an executive session, and Jan, correct me if I'm wrong, but I think you would need 5 individuals from the advisory committee to take a
For
picture.
your meeting, you need 5, so technically your meeting is done. But to go into executive session, yes, you would have to have 5 advisory committee meetings there.
Okay. So
Well,
since we have, go
David,
ahead.
this is Angie. I'm here. I don't know if it shows that I'm here.
it does. Right now, I see Carolyn, Robin, Jane, and Angie.
Okay, just want to make sure.
So one thing that I could offer is, if the advisory committee maybe wanted to do an executive session sort of at a separate time, I could try to look and schedule something for all of you just to come back for that purpose. I believe it would have to be an open meeting first briefly, and then a motion to go into executive session. But since there's not a majority right now, it's something I would offer for the advisory committee if you want me to go ahead and look to schedule that sometime in the future.
I think that's an option if the time works for committee members. Would we have to do a doodle or something to get everybody's schedules?
Yeah, I could go ahead and schedule, send out a doodle poll to check availability for a short meeting for that purpose.
Sure.
And I could go ahead and send it to the advisory committee members to see if we can find a time for that.
Okay, that sounds good. Does everybody else agree?
That would be
Hearing-
fine.
Okay. With that, I guess then we can move on to the next item, which is, I see a shake of a head.
Can we move on, or are we done because we're out of quorum?
You can discuss things, but you can't make any motions.
It's not just that you can't make a motion, but you don't even have a majority, which is required for a meeting.
Okay, so David couldn't give his report, executive report.
Well, Jan, if you could clarify, so does the majority refer to official actions by the committee or just the
The
committee?
meeting, no, it's a definition of a meeting that there's a majority of the members present.
Okay.
Hmm.
So with that, our meeting would be over at this point. We could not proceed. Okay,
You can sit there and discuss, but it's not a meeting. So
okay,
consequently, whatever you discuss, you'd have to rediscuss at a meeting.
okay.
I think we would be better to just open it for the next time and then continue.
Mhm. And then the new and old business could be actually transferred to our next meeting in May 18th. So we could just have the executive meeting and maybe David's report, and we could put them all on the 18th social work advisory meeting, our next meeting. Does that sound okay?
When is the next board meeting? Is it, but it's before May 18th, isn't it?
Yes.
So I don't know if you were wanting to meet to discuss new business before then or not.
So we're looking at executive meeting, we're gonna do doodle, or you're gonna send something out. And then we will add the business meeting.
Well,
To
I can
that?
talk with Carolyn a little bit, to hear her preference on a meeting. One thing would be for the executive session, And then I can work with Carolyn to see if some of the other items might be included during the open part of the meeting.
Okay,
if they're-
sounds good, because I see that some of them really could be transferred to the 18th meeting. They're not like, they're all important, but they could be extended a little bit. But let's do that, David.
Okay, that sounds great.
I'm good with anything, so just let me know.
Okay, we will do that. So at this point, do we have a motion to adjourn today's meeting?
And Jan, you might need to clarify it. Can we
We're
actually?
already adjourned.
We
Can't use-
adjourned when we went out of quorum.
So what do we say?
We're done.
We're done?
I keep switching my mic off and on so I don't interrupt someone, but yeah, you pretty much were adjourned when you lost your majority.
Okay, so we need no motion for that or anything. So
Which-
we could just,
Which probably speaks to when we're on Zoom, that we probably need to have someone watching roster.
We'll be
It's just
keeping
one
an
of
eye-
those Zoom issues.
Yeah, and it's the same thing when you have conference calls too. People need to state when they're leaving, like with Zoom, there's a little chat. And a lot of times people will just go in the chat and say, I have to leave now, so that then that way we can do, someone should be watching the chat. They can see that we've lost the majority.
it's a good idea.
We'll
Well,
keep
then-
an eye for future meetings.
Okay, so watch for the doodle and for our meeting that we're going to be scheduling, David will send out. And so with that, we will say goodbye.
My apologies for going so long. I was yakking and didn't realize we were running out of time. My
That's okay.
apologies.
There's a lot of information, Jan, very useful. Thank you.
Bye, everyone.
Hi, good to see everyone.
Bye-bye.
Bye.